Well, thank you, Mr. Chairman. First of all, I'm not sure the data provided by an individual to the government in, say, an application or a tax return shouldn't be reviewed by the government. That's very different than the government searching for and seizing data that's held by an individual. And I think that's the distinction my friend from Georgia misses. Other than those remarks, I am very heartened by the fact that there is a broad bipartisan concern on this issue, reflected by all of the panelists and almost all of the members. As you know, the history of this goes back to 1761, the trial of James Otis, of challenging the writs of assistance, the general warrants of the Crown. There was a 25-year-old attorney in the audience in that trial who was named John Adams. Many years later, he reflected on the trial and said this. He said, "Every man of a crowded audience appeared to me to go away, as I did, ready to take arms against writs of assistance. Then and there, the child independence was born." In Adams' view, that was the birth of the American Revolution, was the abuse of searches by the Crown. And of course, it was also the birth of the Fourth Amendment. FISA is abused under Democratic and Republican administrations because it's human nature to acquire power and, once acquired, to use it. That's why we divide the powers of government, and that's the reason we have a Fourth Amendment that divides the power of searches between the executive and the judicial branches. And the Fourth Amendment to me is very clear. If you want to look through my stuff, you've got to convince a judge that there's evidence I've committed a crime and list the stuff you want to search for. But we're told that doesn't include metadata, like phone records. So it seems to me that metadata is a record of my electronic activities, isn't it, Mr. Chair?
It certainly is.
So why would that not be equally protected under the Fourth Amendment? Well, what am I missing?
Well, I think it is protected under the Fourth Amendment. I think the reason for excluding metadata searches in the last version of the reform bill was just that searching mere metadata is less intrusive, less dangerous than searching the communications themselves. But I think they both are protected by the Fourth Amendment.
But they're records of my communications, even if it's not a verbatim transcript of them. And then is that not used to get a warrant to review a transcript?
Yes, it could be used.
So basically, a general warrant could be used. What is in effect a general warrant could be used in order to get a specific warrant, correct?
You could view it that way.
And so there's no protection left if we're going to go down that road, it seems to me. One ultimately has to lead to the other.
Yeah, I guess I would still say that the communication itself is more sensitive and more, should be subject to higher protection. But you're right, there is a bit of a slippery slope there, and as the chairman said, the last version was quite generous.
You dealt with the FISA court quite a bit, and I've been concerned about the secret and centralized nature of that special court. I remember looking at statistics from like 10 years ago, and there were like 34,000 warrants that had been requested by the government at that point. Only 11 had been rejected by the FISA court.
Right.
And of course, the approval warrants of individuals like Carter Page were backed by false statements. Not only were those claims not seriously questioned to begin with, as they should have been, but when it came to light that the FBI had lied in its applications, I'm aware of very few disciplinary actions taken by the FISA court. There was one prosecution that ended with a slap on the wrist. What are we to make of this?
Well, I think you've just made the case once again for adopting a robust amicus process in the FISC. Obviously, the individuals who are subject to, who are being investigated can't be told that they're being investigated, and so there's a need to have an independent privacy expert, somebody with a security clearance who can be present in especially sensitive FISA investigations. But
before the FISC, we dispersed that responsibility across the entire court system, did we not? In order to get a warrant, you had to go to a district court judge.
That's typically true in the FISA Title I context. Though of course you go to the FISA court.
Right, but my question is, why don't we go back to the dispersed system where you at least have some decentralization of this awesome power?
Well, there's an argument for that. I think what would be more important is to be sure that that in those decentralized proceedings, if they don't actually give notice to the person who's the subject of the investigation, that the amicus process should be included there as well. It may be more efficient to centralize it in FISC, though.